Verisk's Emerging Issues, your source for vital market intelligence on the evolving risks and opportunities facing insurers and risk managers that can help inform product development and strategic planning. Verisk's Emerging Issues.
Hello, everyone. Thank you for listening. My name is Kevin Sullivan, and I'm an analyst with Verisk's Emerging Issues team. Human trafficking is a multifaceted topic that touches upon different types of illicit exploitation. Here to help us better understand this issue and navigate those complexities is Dr. James Sinclair, Director of Human Rights at Verisk Maplecroft.
Thanks very much for having me, Kevin.
So for starters, tell us a little bit about yourself, your background before you joined Maplecroft, and what you currently do at Maplecroft.
So my background goes back, in my professional career goes back to 2001 when I qualified as a barrister here in London, so an attorney, as you would know it in the US. And I spent the first 5 years of my professional life in private practice. So I was practicing as a lawyer. And then in 2006, I met some guys who had been in the army, or ex-military guys, and they were then working in Iraq and Afghanistan during the conflicts there, principally in security roles and in roles related to various sort of government activities. And we got talking one day about some of the activity that they were seeing and that they were concerned about. And that activity we would now understand as bonded labor and forced labor activity. And this typically was involving what we call third country nationals. So people from Nepal, from India, from East Africa, who were being employed to support US and UK and European government operations in places like Iraq and Afghanistan. And the concern was principally about the way in which these workers, these third country nationals, were being recruited and then managed. And what transpired was that they were having to pay very large amounts of money to get their jobs, in some cases $5,000-$6,000. And in most cases, they couldn't pay that money. And so they were lent it at very high rates of interest. And that debt bond, as we would now call this problem, one of debt bondage, was then effectively used as a lever to potentially exploit them, or at least reduce their capacity to complain about inappropriate working conditions or low pay, etc. And so I got talking to them about this issue, and we tried to raise it at various sort of political levels, but that wasn't working. So we ended up starting what I think was the world's first dedicated ethical recruitment service for migrant workers in the security industry in 2006 in Nepal. And it was a bit of a leap of faith for me because I was enjoying quite a comfortable career at the time as a lawyer. And then suddenly I'm finding myself wandering around in villages in Nepal and in India, setting up recruitment centers for people. But in that process, over the course of the next 5 or 6 years, I learned a lot about forced labor and its various manifestations, and about the whole sort of panoply of what we would now think of as business and human rights. And at the time, that term wasn't really that well known, if at all. It was before the United Nations Guiding Principles had come into effect. So we were somewhat flying blind. But over the course of the next few years, we established this company, it's called FSI Worldwide, into a presence in 10 countries. And we eventually won the 2013 UN Business Leaders Award for recognition of the fact that we'd taken tens of thousands of people out of exploitative working situations and into decent work. And that then led me into work with the US government and to set up my own law firm and other things. Eventually, I wrote a PhD thesis and a bit of a book on this issue, and then finally joined Maplecroft about 3 years ago, where I head up the human rights group here within the Sustainable Procurement and Human Rights team. And what we do on a day-to-day basis is essentially two things. We have our data set, which I think you're aware of, which looks at a whole range of human rights and environmental and sustainable procurement and geopolitics and other issues, and provides companies with a risk exposure map, that sort of a heat map of their risk exposures in relation to those issues. We also provide high-level advice to companies as to what to do with the insights they get from that data. So once they've understood where their risks are, they then need to take action to address those risks. And so the human rights team comes in and helps companies, particularly sort of at the senior leadership, to think about how to develop strategies and policies and supplier engagement protocols and remedial actions and communications. So the advice that we give is largely structured around the United Nations guiding principles and the OECD guidance for multinational enterprises, as well as, of course, the emerging legislation that we're seeing, particularly coming out of Europe. So very broadly speaking, that's what I do.
Thanks very much, James. Really interesting. Speaking of the United Nations, the UN and other international organizations have similar, at times overlapping definitions for various trafficking in persons. Can you tell us a little bit more about what types of illicit activities constitute human trafficking? I know you talked a little bit already about your earlier work and current work in forced labor, but would you be able to expand on this term a little bit more broadly for us?
The definitions here can trip people up a little bit, and so it's important I just take a few moments to explain the way I see these definitions. And when I say the way I see it, it's because in some cases, there isn't a commonly agreed approach to some of these things. So some of this is me giving you my opinion. Of other bits of it will be based on hard law. When we talk about human trafficking or trafficking in persons, this is a term that is most frequently used in the US context to refer to both, if you like, the moving of people and the substantive exploitation of those people. Now, to make things seem slightly more complicated, the US doesn't actually require the movement element, so it's a slightly complex thing. The US has based its definition of human trafficking on the Palermo Protocol from 2000, which is a UN protocol, and that talks about the recruitment, the transportation, the transfer, the harboring, and the receipt of people using force or fraud with the intention and purpose of exploiting them. So it covers the act, in other words, the act of something like recruitment or transportation, the means, in other words, by fraud or by deception, and the purpose, which is to exploit someone either typically for labor or for sexual exploitation purposes. And those are the two, when we talk about the substantive elements of human trafficking or modern slavery, that's what we're talking about, essentially labor exploitation related to sexual activities. So those are the key things to remember. It is slightly complicated by the fact that internationally, at least, the term modern slavery is often used as an umbrella term to include things like forced labor and child labor, the worst forms of child labor, and it also includes human trafficking as essentially the facilitative offence. Now, this doesn't quite work at the margins of the definition, but if you think of it, the trafficking element is basically, taking someone or moving them with the purpose of exploitation. And then the sort of substantive exploitation is either the labor-related or the sexual exploitation-related activity. So on one level, there's some complexity as to the definitions here. On another level, it's quite straightforward. It's the exploitation of other human beings for your own profit. And that is obviously, in some ways, that's quite an easy thing to understand. And unfortunately, it is a large problem. At any given moment in time, it's been estimated that about 50 million people in the world are in circumstances that would meet the threshold of either modern slavery or trafficking in persons, if you want to use that definition, with just over half of them being in labor-related exploitation, with the rest being in forms of sexual exploitation and slavery.
Now, you touched on the sort of the U.S. lens on this a bit, and in 2000, U.S. lawmakers passed the Trafficking in Persons Act, and in subsequent reauthorizations, expanded the statute to address claims against quote-unquote beneficiaries of human trafficking, in addition to its perpetrators. Federal prosecutions of human trafficking crimes increased since the passage of this legislation, though U.S. Justice Department data reveals that bulk of these cases tend to pertain specifically to sex trafficking, which you touched on just a bit before. Why does this tend to be the case, do you suspect, especially in light of reports and data, including your own, suggesting, for instance, that forced labor violations maybe are on the rise in the United States?
It's a really good question, Kevin, and I'm not sure that I have a particularly good answer to it. And I think any answer I give is likely to be no more than my own understanding. I think the issue is this: that we all understand that sexual exploitation is an abhorrent criminal activity, and it is something that is understood as being a clear criminal justice issue. And as such, although it is, of course, as I say, it's an abhorrent activity, it's sort of easier for people to understand. And so, from a law enforcement perspective, it's quite straightforward. You investigate a crime of this nature, and you seek to bring the perpetrator to justice. And as you say, the net is now widened out to not just include those people who are perpetrating the crime, but those who are benefiting from it. So that at least conceptually is relatively straightforward. Labor-related exploitation tends to be slightly more difficult. It is sometimes more of a political economy problem than it is a criminal justice issue. By that, I mean that there are a lot of the people who are currently in circumstances of labor-related exploitation know and understand that they are being exploited, but if given the choice, they would not leave that exploitation. And that feels like a strange thing to say. But ultimately, people take exploitative work for all kinds of reasons. Of course, at the most extreme end, people are being forced into a situation and they're being held against their will, for example. And of course, those people would, if you like, escape given the chance. But then there's a whole sort of group of people for whom it's not so black and white. And they might be undocumented migrants or have some other form of irregularity in relation to their status, and so therefore are pushed into the shadow economy, and they're working for cash and off the books. And of course, that makes them inherently more vulnerable to exploitation. But it is also work that they would probably not like to lose. In other words, if you intervene in that situation and say, well, look, this person is being exploited because they're being paid less than they should be being paid, or their working hours are too long, other forms of exploitation and abuse, it's entirely possible the person wouldn't thank you for that, because for them, this job might be exploitative, but it might be a lifeline. It might be the only thing that's keeping them from destitution. We have situations in parts of the global south where the only alternative to exploitative work is no work at all, which is not to say that we should accept exploitative work, or that we should throw our hands up and say, well, there's nothing we can do here. But it is to try to understand that there are shades of grey in this activity. And so I think this is possibly why the criminal justice system finds it easier to cope with something that is so obviously criminal, as it is in the case of sexual exploitation. Whereas labour exploitation, other than at the margins, which is where it often is quite clear, that the bulk of it tends to be more of a question of how companies are policing their supply chains, for example, and to what extent companies both in the US and overseas are able to enforce higher standards of labour rights, not just within their own workforce, but in the workforces of their suppliers and sub-suppliers. And so this problem becomes quite difficult to get your head around quite quickly. And as I say, we're dealing largely in shades of grey rather than in clear black and white. I don't know if that makes sense, but that's about as good as I think I can do on that question.
Absolutely, it's interesting, and I think it speaks to the complexities of the buckets of the topic that they tend to be in. You touched upon exploitative labor conditions outside of the U.S. a little bit there, and of course, just to that point, we know that U.S. supply chains, of course, don't end at the water's edge, and often depend on an array of suppliers and manufacturers all around the world, as you mentioned just a moment ago. Can you speak a little bit more to some of the human trafficking concerns that could expose U.S. businesses to potential risks today and perhaps in the years ahead?
Well, I mean, I think the first thing to say is that this is primarily a human rights problem. And whilst we do need, obviously, in our business, particularly to consider the risks to business and seek ways to address and mitigate those risks, we should always bear in mind and keep at the front of our mind that the problems associated with human trafficking, forced labor, modern slavery, call it what you will, are primarily a human issue. And the impact on individuals and on communities of these practices can be and often is devastating. So I think whilst we, as I say, we can and should talk about the impacts on businesses, we should always keep our focus on people. When we think about businesses, I think there are lots of issues that are starting to come into play. If I think back to when I started my sort of business and human rights work, it was typically the case, and I think is still the case now in some instances, that businesses saw that their responsibility was to police themselves and their own operations, and that there was a wall around them, was sort of impregnable, if you like. So the law, didn't extend beyond their boundaries, and that their suppliers, it was the job of the supplier to look after their own workforce and to think about where they got their component parts from, all the way down to sort of raw materials. What is changing over the course of the last few years, and which will accelerate over the course of the next few years, is the breaking down of those walls. And so we're moving into a situation in which it is no longer acceptable for large companies operating in global supply chains to essentially wash their hands of whatever it is that's going on in tier 1, 2, 3, 4 of their supply chain. The law is turning against that idea, and it is making it clear that companies do have responsibilities for workers, for communities, for the environment, and indeed other things beyond their own operations. And we're seeing that concept manifest itself in a series of legal changes, particularly coming from the EU. But before I get to the EU law, it's worth just going back and remembering that these concepts, this idea of responsible business practices, is not new. It's been around for decades and was codified most eloquently in the United Nations Guiding Principles on Business and Human Rights in 2011, and the OECD guidance, which was updated in 2011 and updated again in 2023. So, and those core framework foundational documents run through a lot of these new human rights and environmental due diligence laws that I'm just going to talk about in a few moments. It runs through those laws like a stick of rock, as we would say in the UK. Now, they are absolutely foundational, and they make it clear that it is business's responsibility to respect human rights by making sure that they have in place appropriate and effective mechanisms to ensure that rights are respected, that communities are respected, and of course, increasingly now the environment is respected. Those core principles, those due diligence principles, have now been given statutory effect in the EU by instruments such as the Corporate Sustainability Due Diligence Directive, which is coming into force over the next couple of years, by the Reporting Directive, which is already in force, by things like the deforestation regulations, the forced labor regulation, the sustainable finance regulations. There are a whole raft of legislative interventions which sit under the broad banner of what's sometimes known as the EU Green Deal. It's not just in the EU. The US has, of course, its own suite of regulations in this area, whether you're thinking about the SEC type of regulations or other sort of federal agencies looking out for the environment. And increasingly, this is overlapping with trade issues and geostrategic issues. And I'll just touch on that briefly before going back to this extraterritorial point, if I may. But the trade issues are in some cases fascinating because, of course, there is, as everyone knows, been a certain amount of geostrategic tension between the US and China over the course of the last decade or so. That doesn't look like it's abating anytime soon. And there have been examples, cite the Uyghur Forced Labor Prevention Act as being a good example of a piece of legislation which is ostensibly a human rights instrument, but which is also a form of trade ban. And this is where the line between human rights and environmental legislation and intervention crosses over into questions of geostrategy and geopolitics. And I think we need to be very careful as a business to make sure that we are not drawn too deeply into that quagmire, because our job is to provide objective data and sound advice based on sound international principles, rather than necessarily getting into the sort of the trade war issues. But just to go back to some of the concerns that I think businesses might have. Obviously, there is this new regulatory environment, which is much more consequential and much more demanding than it has ever been before. And that is clearly going to be something that will exercise chief risk officers and general counsel and boards generally across the US and Europe as they come to grips with how to implement these due diligence procedures into their business, and increasingly think about the panoply of reporting obligations they have. So there's definitely legislative pressure, and there are also some pressures relating to litigation, to reputation. Clearly, companies that are involved in or accused of labor rights abuses or environmental destruction, it is clearly not going to have a positive impact on that company's reputation. So, it's important for companies to be thinking about now what they do, how they do it, where they do it, with whom they do it, and on what terms they do it. Kind of actually quite fundamentally rethinking some aspects of their business. And so, and I'll finish with this point, if I may, Kevin. There has been this feeling amongst us lawyers, I have to say, looking at my own profession for many years, that all you need to do is articulate the obligations that your supplier owes to you, clearly in a black letter fashion, and then pass down obligations to your suppliers under threat of dismissal if they get it wrong. That sort of risk-averse risk management approach has been the sort of dominant paradigm for a long time. Squeeze your suppliers, try to get as much out of them as you possibly can, as quickly as you can, as cheaply as you can. That's sort of the rules of the game. And what's interesting about the EU legislation in particular is that it seeks to change the rules of that game in a more profound way than might be suggested by just a sort of due diligence law. If you read the advice and the guidance that accompanies these laws, particularly the German law, it talks about a much more profound move towards a collaborative approach with your suppliers, being much more open and engaged with suppliers, so that you're not setting them up to fail, but you're setting them up to succeed. And this is not without its controversy. There are plenty of both businesses who say that, again, it's not my job to run my supplier's business. But I think increasingly that is the message that's coming from the European Union, that to some extent, if you're a large international player, you do have obligations through your supply chain and value chain. And therefore, it's important that we start to pivot our businesses to think about sustainability much more holistically, rather than thinking about pure narrow business interests.
This is really interesting what you bring up about this sort of increased awareness and responsibility about business supply chains. I'm wondering if, with that in mind, perhaps we could home in a bit on the topic of so-called critical minerals. It seems unlikely that the global appetite for devices such as smartphones, electronic devices like electric vehicles, and other innovations is likely to dissipate in the coming years. We know that these essential materials are often concentrated in parts of the world that are plagued by poverty and political instability. Much of the world's cobalt, for example, is mined in the Democratic Republic of Congo. Notably, Verisk Maplecroft's country snapshot of the DRC describes the country as, quote, an extreme risk environment with regards to human rights, and significantly underperforms the regional average on our social and human rights indices, end quote. Can companies potentially meet these growing consumer demands while also exercising effective human rights due diligence?
Well, Kevin, I think that is the multi-billion-dollar question. It is, I think, going to be something that is has been exercising companies mines for some time and will increasingly be a problem going forward. There are some people who say, and I think with some justification, that you can either have human rights protection or you can have a rapid transformation of the economy towards more environmental sustainability, but you can't have both. I think that is possibly putting it a little high, but I do understand the sentiment because if you think about where the world's critical minerals are being mined, it is in places like the DRC, other countries as well. But it is notable that these countries are often beset by significant challenges in the mining and production of those critical transition minerals. So cobalt is one example. There are plenty of others. The question is, are there things that you can do meaningfully to intervene in those supply chains? And then we come back to the question of ownership. So who is it that owns these mines? How open are the governments in those particular countries to change? And what leverage does the company buying those minerals have? And if we look at those questions in turn, we see that in many cases, China owns a lot of the mining capacity for cobalt in the DRC. I haven't got the exact figures in front of me, but the last time I looked, the entire supply chain for electric vehicles was dominated by China. I mean, to the extent of about 70 or 75% of everything from the mining of raw materials through to final production. And the same is true for solar and wind technology to some extent. Then you have a question of, well, does China take a materially different approach to human rights protection to other countries that might own these assets? And I think we can say with some certainty that they do. And it's important that we're not here to sort of demonize China. China is a very complex an interesting country in many ways. It is both a leader in renewable technology, as we've seen. It controls a lot of the supply chains, but it is also installing far more wind and solar than anyone else. But at the same time, having been credibly accused of some human rights abuses. So it is a complex challenge. So that then we also have the issue of the local governments in countries. There is unfortunately a good deal of corruption that bedevils a lot of the countries that are hosts to the critical mineral mining. And so the question then turns to what companies can do about that, because these minerals are in relatively short supply. The demand for them is outstripping the current ability to supply. And so in that sense, the power dynamic is not with companies who are looking to buy the minerals. It is very much with the governments of those countries and the owners of the mines. So this is a really complex problem. Now, it seems to me that there are several ways in which we might be able to address those problems. And I think answers that could come at the governmental level, which obviously is slightly outside of the ability of companies to influence. And then there are things that companies themselves can do. At the governmental level, I think there are opportunities for multilateral or other forms of engagement, and it seems to me that this is an area that is ripe for discussion, where it doesn't help anyone if we are setting ourselves in this zero-sum race for these critical minerals, because all that will happen is we'll end up with even more human rights abuses and environmental destruction. So it does seem to me that there could be scope for more intergovernmental cooperation here. Of course, it won't have escaped your notice that intergovernmental cooperation is in somewhat short supply at the moment. And we are moving into an era, have been moving into an era of increased nationalism and to some extent resource nationalism over the last few years. So I'm not holding out too much hope of an intergovernmental solution. So then that brings us back to what can companies do individually to try to ensure that their supply chains are not beset by these problems. And I think there are several things you can do. Obviously, the first thing is to understand and map your supply chain in detail, so you understand exactly where it is your minerals and your other goods and services are coming from. And once you've done that and you've created a heat map of your risk, if you're in somewhere like the DRC, that's likely to be flashing quite high risk. Then you need to be engaging really firmly with the people from whom you're buying, and to identify ways in which you might be able to bring your influence to bear to improve labor rights conditions and other sort of human rights and environmental rights in that area. And there are things that companies can do, things that companies are doing. We speak to mining companies, we speak to other companies in the extractive industry, and we know that many of them do care a lot about exactly how they get their metals and minerals out of the ground. So it isn't the case that companies are just turning a blind eye to this. They are concerned, they are engaged. But I think, as we said earlier, they are going to need to be more engaged than ever to try to make sure that abuses are not happening. And in the last resort, if they cannot make changes, then they will need to think about diversifying their supply. That, of course, is easier said than done, because in some cases, supplies of particular minerals only come from particular countries or particular parts of countries. And so the question then before you is, do we want this commodity or not? And it's very difficult for companies to say, well, actually, we're going to do without it, because critical minerals are critical. And so I don't have any easy answers to this. If there were easy answers, I'm sure we would have heard about them by now. But I think it does come down to heightened due diligence, being very aware of the international standards that are expected. And you think about the ICMM or other international bodies, they're very clear about what is and what is not acceptable for mining companies and others to be engaged in terms of labor rights practices, human rights and environmental practices. So it's not as though there aren't any international standards at play. The problem is the enforcement of those standards. And that's where I think we need to be much more focused.
It's interesting. And you touched upon steps that companies can take to be more aware of what's going on in their supply chains. I was wondering if I could ask a little bit about efforts by other parties. Holding US companies, for instance, legally liable for their supply chain activities overseas has, at least in some cases, proved ineffective. Is this a pattern that has perhaps repeated itself in other forced labor cases pertaining to US-based firms, or any examples that you're aware of?
I mean, I should start that answer by saying that I'm not a US lawyer, and I'm not an expert on US litigation. I've read some of the cases, and I'm broadly familiar with the general principles, but I don't hold myself out as an expert in that space. But I do think that litigation has proved itself to be a somewhat unreliable tool in the fight for sort of corporate accountability, if you want to call it that. And I can use examples from this side of the pond, perhaps in the UK, where I know a little bit more. But I think we've seen a few years ago in the UK, there was a famous case that went all the way to the Supreme Court, the Vedanta case, which looked at the liability of a London-based company for harms that had happened in a subsidiary company in Africa. And so the question there was, to what extent is it right for the parent company to be held liable for the failings of its subsidiary? And the finding in that case was that in that particular instance, it was fair and reasonable to ascribe liability to the parent. But the particularity of that case was such that it probably doesn't produce much of a precedent in terms of other companies. The situation of that company was very particular. So, and we've had more recently the Shell case, the Milieu Defensie and Shell case in the Netherlands, which was about the extent to which Shell should be forced to reduce its emissions, the Scope 3 emissions, by 45%. And the court in that case said that it was not reasonable to ascribe that figure to Shell, although it said some very interesting things about the broad requirement of the company to respect international human rights and environmental treaties. And it's certainly the case that I think companies are going to come up against some interesting litigation regarding the Paris Agreement of 2015, which has been written into some of the laws I spoke about earlier under the European due diligence legislation. And so I am expecting to see more litigation on that front to clarify exactly what it is that companies are required to do to mitigate their contribution to climate change. On the human rights side, I think we're seeing, in some ways, sort of mixed messages about what it is that courts are expecting of companies. And to some extent, that might just be that the jurisprudence is playing catch up with the legislation, because when we talk about in the US context, there isn't the same kind of explicit legislation that we're starting to see in Europe. It may follow. It's in some cases, I think, unlikely in the next few years. But if it did, then I think the US courts would have more to bite on. But at the moment, they're having to rely on some slightly tangential legislative requirements. So, but in the UK context and in the EU context, I think we're closer to the courts establishing principles which say that companies can be held liable, should be held liable for human rights and environmental violations that happen on their watch, even if they're not happening directly within their organization, but which are happening in their subsidiaries or their suppliers. And I think we are starting to understand that the jurisprudential norms are evolving to such an extent where court action, at least as I say in the EU and the UK context, is probably more likely. And I do think that it is a significant risk that companies need to be factoring in when they're thinking about their risk profile here. So it remains to be seen how all of that develops. But certainly to date, I think we can say that the litigation has not been the sort of slam dunk that I think a lot of people thought it would be a few years ago.
James, finally, you have talked a little bit about policies that have been adopted in Europe on this issue. And I'm wondering, are there other steps or other measures that other international bodies are taking to address this challenge that you feel might be worth mentioning? And if so, is there anything that US stakeholders, whether we're perhaps talking about policymakers, regulators, or again, US businesses, might want to consider learning some lessons from?
Yeah, I think there are some really interesting good practices emerging. And as ever, I go back to the excellent OECD guidance documents and all of this. There's some really good guidance out there for companies and indeed for governments on how to effectively police your operations and supply chains. I'll just pick up a couple of examples, if I may. So, from this side of the pond, the UK has passed some quite interesting, or developed and put into practice some quite interesting policies at government level. So these are typically procurement policies, or public procurement notices as they're called, which set out the detail of how they expect government purchasing agencies to behave in certain circumstances. For example, there's one that was passed in 2023, which is about modern slavery, and all UK government departments need to abide by this purchasing practice, this procurement practice. When you think that in any given country, the government is usually the largest purchaser of goods and services, how the government goes about buying those goods and services is a really critical question, because it doesn't just have an oversized impact on the buying itself. It also sends a signal to the rest of the market about the norms that are now expected, and it does to some extent cascade down through the supply chain. So I think that's a really interesting initiative, and one that is worth looking at. From the corporate side, I think there are some really interesting examples of companies that are doing really good work here, and importantly, they're talking about that work in a really impressive way. The sort of poster child, I think, for that in Europe, at least at the moment, is a delicious chocolate brand. I'm far too fond of it for my wife's liking, but it's a very interesting company, because they have put their human rights and environmental strategy front and center in their marketing. So when every year they come out with another report and they say, good news, we found more child labor, which sounds like a really odd thing to say for a company. Ordinarily, that kind of thing would be buried. But actually, what they're saying is we found more because we were looking harder. And because we're looking harder and we found more, we can do more about it. We can do more good. And this is a really interesting strategy because it turns the whole idea of risk management on its head. And it's in my view, it's a grown-up way of looking at the world, because everyone understands that companies in the chocolate or cocoa supply chain are going to have problems. They're going to have issues with child labor, notoriously, but also with other forms of labor and human rights and environmental abuses. So the question isn't, do we have those problems? The question is, how do we address them? And I think approach, which is to say, look, let's all be grown up about this. We have problems. This is what we are doing in detail to address them. We have invited other companies to engage with us in a sort of open supply chain initiative so that we can all learn from each other and we can disseminate best practice. That feels to me like a very grown up and innovative way of approaching this. And I think that is going to be something. So both the strategy itself and the way in which it's communicated, I think, is something that we can all learn from. And in the coming years, I would expect to see more of this as the market sort of shifts in that direction. But it is a challenge. It's a challenge for those of us who work in forms of corporate risk management, if you like, those who sit in general counsel's chairs or chief risk officers' chairs or chief executive chairs. Those are people who typically only ever want to tell a good story, a positive story, about what the company is doing and how it's behaving. But the reality is that global supply chains in large corporations are messy and they're complex, and in some cases there are pockets of bad practice that need to be focused on. And so we can't just be telling a good news story all the time, because that's not realistic. So I think the learning from this is trying to put in place a kind of realistic, grown-up approach to all of these issues and demonstrate that you have a methodologically sound platform for action. You've got you've got the data, you've taken advice, you've put in place a robust strategy, a set of policies, and you're attacking the problem as appropriately as you can. And if you can demonstrate all of those things, then I think the public at large is quite forgiving of the odd failure. The outcome in that sense is less important than the process, albeit obviously the outcome's very important from a human rights perspective, but from a corporate perspective, if you've got that process in place and you can demonstrate that you're taking real and meaningful steps towards positive change, then I think that goes a long way to meeting the concern and the risk. Because if you turn up in court and you say, well, look, we've done our absolute best to address all of these risks, that is all that is required of you. Under this new sort of suite of legislation I talked about earlier, it's a risk-based, proportionate approach. No one is expecting companies to fix all of their problems in year one. That's not what's required here. What's required is a detailed methodological approach which understands those risks and treats them accordingly.
James, I'd like to thank you for your time today. We have links to more information on Verisk Maplecroft and their excellent work on our website. We encourage listeners to check that out and to also sign up for the weekly Emerging Issues newsletter while you're there. James, thank you again.
Thanks, Kevin.
Verisk's Emerging Issues, your source for vital market intelligence on the evolving risks and opportunities facing insurers and risk managers that can help inform product development and strategic planning. Verisk's Emerging Issues.